You've been on trial for 2 weeks now. Hard-fought weeks where everything is contested, everything is disputed. And now, during the middle of trial, each side agrees to settle its case, and your case is now over. The jurors have been paying close attention. They've now been told your case is over. Is it appropriate for the jurors to approach the attorneys to ask, why did the case settle? And for how much did it settle for? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney, and the answer is yes, it is appropriate for the jurors to approach the attorneys and to ask these questions. You see, these jurors, members of the community, have invested their time to sit in judgment on your particular case. They've agreed to give up things that they would normally do during their day, whether it's going to work, spending time with their family, or other things they have to do. And now they're sitting in judgment. They're waiting to get to the point where your case is now over. And now they have to decide whether you are more likely right than wrong. But in the middle of trial, each side has now agreed to settle this case. And now the jury wants to know, why'd you do that? You just short-circuited the whole legal process, and now we're stuck. There's no ending. Tell us what happened. Can the attorneys disclose that information to the jurors when they approach them in court? The answer is, yes, they can. Unless there is an agreement amongst the parties not to disclose that information. And in many instances involving medical malpractice cases, the defense wants to have a gag order. And what that means is they don't want the terms of the settlement disclosed to anybody. They don't want it disclosed online. They don't want it disclosed offline. They don't want it disclosed to the news media or even to the jurors who participated. So if there is that agreement in place, when the jurors come over and ask, hey, can you tell us what happened and how much you settled for? In that instance, we would not be able to tell them. 2 or 3 years, we had this ongoing dispute. They wouldn't budge. They wouldn't agree to settle this case. And now it's only because of all this testimony, all the evidence, and the risk that you, the jury, were going to come back with a verdict way in excess of what they thought the case is worth. That's what prompted them to go ahead and start negotiating. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these civil lawsuits here in New York. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.